Welcome to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. And now your hosts, Tim Kowal and Jeff Lewis.
Well, welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. This podcast is a resource for trial and appellate attorneys. Jeff and I are both appellate specialists, but we split our time about evenly between trial and appellate courts, and we try to give our listeners in each episode some news and perspectives they can use in their practice.
And a quick announcement, this podcast is sponsored by CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse the service. Listeners of our podcast will receive a 25% lifetime discount available if they sign up at casetext.com/CALP. That's casetext.com/CALP.
All right, Jeff, and today we are pleased to welcome Peter Prows to the show. Jeff, I was telling you that what we really needed to entice listeners to come to the show was a really juicy CEQA episode about CEQA environmental law. And so Peter Prows fits the bill. Peter is counsels public agencies, private clients, and sovereigns on all matter of water, land use, and environmental issues, including neighbor disputes, development permit issues, and all the way up to national bet the company federal litigation. Peter is experienced in California's water rights and quality laws, the Clean Water Act and wetlands regulation, the Coastal Act, CEQA, of course, and NEPA, and the public trust doctrine, real property, and the law of the sea. He litigates in state and federal trial and appellate courts, including the California Supreme Court and the United States Supreme Court. Peter has been a law clerk to the Honorable Charles Brower in his private international arbitration practice in London, and he was a law clerk to the Honorable Abdul Karoma of Sierra Leone at the International Court of Justice in The Hague. Peter, welcome to the podcast. Thanks for joining us.
Thanks so much for having me, Tim and Jeff.
All right, well, I have to start at that last one first. You were a law clerk in The Hague. What is that like?
The Supreme Court of the world. No, the International Court of Justice is the principal judicial organ of the United Nations. It hears and resolves disputes between member states of the United Nations. They typically get there, they all have to get there by consent of the parties, and that consent typically comes in the way of dispute resolution provisions in treaties. So these days, a lot of the cases the International Court of Justice hears are maritime boundary disputes, because the UN Convention for the Law of the Sea has a dispute resolution provision that provides consent, at least in some cases, for the International Court of Justice. And so several of the cases that I worked on while I was there were maritime boundary disputes. We also heard a large dispute under the UN Genocide Convention between involving Serbia. So it was an exciting experience. I think the listeners of your podcast would find it rather enlightening to listen to oral argument at the International Court of Justice. The counsel submits their oral remarks ahead of time and reads from a script. That's oral argument. The judges, when they ask questions, will submit them in writing to the counsel and give them a couple weeks to get back to the court on their responses. There's no sort of live Q&A.
That's the extreme version of tentative opinions.
Yeah, well, it's sort of out of respect for the fact that the parties are sovereign countries, and that the mere counsel, mere attorneys don't have the authority to bind a country to their responses sort of on the spot. That's the theory anyway, but it leads to fairly dry oral arguments that actually sometimes go on for multiple weeks. It's less of an argument and more of a presentation that will go on for it can be weeks.
Yeah, multi-day or multi-week presentation.
Mm-hmm.
So Peter, your practice is in San Francisco. You have clerked at The Hague. You've clerked in London. You are versed in the law of the sea. Tell us a little bit about your practice and how all those dots connect.
Well, in law school, I didn't really know what kind of law I wanted to practice. I
chose D, all of the above.
All of the above. I went to law school in New York. I had the big firm summer associate experience in New York. I'd done arbitration practice, which I could have gone back to after working in The Hague. But I'd had the opportunity while I was in New York to work for a small island country, Palau, at the United Nations. And I had kind of a menu of issues that I could have helped advise them on. And the ambassador at the time offered me law of the sea. And I thought, well, that's actually an issue that a small island country might find useful to know something about. So I learned as much as I could, and ended up negotiating fisheries agreements and maritime boundary issues at the UN, and working with scientists and geologists and biologists. And when I was coming to the end of my time clerking, and I was reflecting on what I really wanted to practice, I came to the realization that I really loved the environmental stuff. I learned something new in every case. I worked with people who were smarter than me all the time. And I got to meet scientists and really engage in public policy and do public law work in a way that, I'd never be able to do going to sort of a large commercial litigation practice back in New York.
Right. So I take it you
yeah.
came to it with an interest, pre-existing interest in policy, international issues.
Yep.
Yeah. Okay. And here's a stupid question. Law of the sea and maritime law, same thing or different things? Different things.
So far as I can tell, I don't actually know anything about maritime law. Maritime law is sort of the law of ships and marine commerce. And so, you have sailors who slip and fall on a vessel.
It's like tort law on the water.
Yeah. And it's an old form of law. It's actually one of those creatures of federal common law that we're told don't exist, but actually do exist in some realms, and maritime law is one of them. But I know nothing about it. Law of the sea really is where one country ends and the high seas begins, or where another country begins, and what each country's rights and responsibilities are in the different areas of marine jurisdiction.
Okay, so when I go off on my friend's boat, you can tell me where we can start gambling and doing other things that are otherwise illicit.
You might not like the answers, but yes.
Okay. All right. Let's see. Would you rather be in state court or federal court? You practice everywhere. Where is that? What are the pros and cons? Where would you rather be?
I am comfortable in both. If it's a state court I've been in before, then I probably will say state court. If it's one I haven't been in before, then federal court. Federal court practice, at least in my experience in the Northern District and the Eastern District here in California, is fairly similar. You don't have the local rules. Filing is all online, so there's no real mystery about how to get something before a judge and get it filed. Whereas in some state courts, it can be a real trial and error to figure out even how to get something filed, to get it before the judge. Which judge do you end up before? Once you've gone through, having a case in a state court, and you kind of figure out how it actually works, then, it tends to be a smaller, more collegial a practice, I think, when you know the judges and maybe you have some experience with the court clerks, and it tends to go fairly smoothly. So if I've been in that court before, I'll say state court. If not, then all else being equal, federal court.
You have a good war story you can share, or something that was formative to your practice, maybe something that confirmed that I'm in the right area of law, or something, or maybe a story that told you I got to get far away from this kind of situation.
Well, I was reflecting on that, and it actually involves a criminal case I was involved with once. I don't do a whole lot of criminal practice, but I've had a few matters where particularly farmer clients have gotten themselves into trouble. It's harder being a farmer in California than you might think. But I had a client who was an oyster farmer, and there's a statute in the Fish and Game Code that says, you got to fill out a form each year that tells the state where you got your oyster bags. And he had oyster bags in 3 places. and he listed all 3 on one form. And the warden, I guess, thought he should have filled out 3 forms instead of 1 form. And any violation of the Fish and Game Code is a misdemeanor. So he got criminally prosecuted for this.
For filling out filling out a form the wrong way.
Yeah.
It's kind of like talking with the FBI. You better not make even an innocent misstatement.
So my comparative advantage, shall we say, is not in the criminal courtroom. But I thought, well, you know what? I'm not actually sure this is a crime. So I bet the DA here has never seen a demur in a criminal case before. But it turns out you can actually demur to a misdemeanor complaint. And so I filed a demur, and the judge overruled the demur, but then took me and the DA back into chambers. And I'd worked on a fairly high profile case. This was in Marin County a few years prior, and was representing another oyster company in litigation against the National Park Service. And the Marin County had gotten involved in that suit, and our judge had worked in the county counsel's office at the time. And she, after she'd ruled against me, she turns to the DA and says, "You know who this guy is? He's the oyster lawyer. You don't want to go up against him, do you?" And let's just say the case promptly settled quite favorably almost immediately thereafter. So sometimes even when you don't feel totally comfortable in one area of practice, if you can bring whatever comparative advantage you do have to it, as well as whatever reputation you've garnered to that point.
Well, that's right. Now I feel remiss for not introducing you as the oyster lawyer. All right, well, let's move on from oysters to CEQA. We've not had an attorney on the show to talk about CEQA before, and I wonder if you tell our audience a little something about your work in that area. How much of your work is CEQA? Who are your typical clients? Are they developers? Are they municipalities? Are they the NIMBYs? Who are they?
Well, I'd say almost all of my cases involve CEQA in one form or another. I represent developers. I represent public agencies, water agencies, and I've even represented petitioners who have challenged projects. But anytime you need a discretionary permit from a public agency in California, CEQA is going to be something that you have to think about. Public agencies, when they approve a project, have to do CEQA unless some exemption applies, and those exemptions are litigated up, down, and sideways. But CEQA is involved in almost almost every matter I am engaged with.
Many land developers and public agencies grumble about how long it takes to get projects past CEQA. Does CEQA, in your opinion, unduly slow projects down? And are there any efforts to reform CEQA and make it a little easier to navigate?
CEQA itself says that the environmental review process should be done within a year. In my experience, that almost never that goal is almost never met, though I'm involved in a project now where the permit application went in March, and we're on track to have EIR certified in November. So I'm trying to break a new record here, and we'll see how it goes, and we'll see if we get sued on the project later. Knock on wood.
So what is the effect of this goal of completing the litigation within a year? Do CEQA, I think CEQA actions get calendar preference, is that right?
They do get calendar preference, yep. Really, until the CEQA issues are resolved, it's hard to proceed with a project. And I think those goals are really intended to recognize that this process isn't supposed to take forever. There is supposed to be finality to it, and that's part of the reason why there are such short statutes of limitations in CEQA actions, sometimes as short as 30 or 35 days,
right?
Which the California Supreme Court has been pretty strict in applying. So yeah, we are supposed to get through CEQA and get past CEQA. It's not supposed to be the be all and end all of the land use entitlement process, though. I have other projects where it's taken 5 years or more, and then there are lawsuits, and then those can drag on for a while as well. So the legislature in recent years has enacted a number of bills to to streamline the CEQA process or exempt certain projects from it entirely.
What types of reforms are on the table?
A lot of them involve infill projects in urban areas where the project meets the pre-existing general plan and zoning. So essentially, if you already qualify under the city's requirements, then there really shouldn't be further CEQA review. These projects qualify for, you know, streamlined ministerial is the word the statutes use, approval. And when
So
a
this
project
would mean that that these infill projects would not have to go through the entire panoply of CEQA procedures.
That's right. They actually are exempt from CEQA entirely, and
Oh.
there are certain concessions in that legislation to requiring certain percentage of affordable housing to be built as part of the project, and often project labor agreements, meaning you got to pay union wages for those kinds of jobs, and so there is some question about how economic those projects are once those components are built into them. But if you don't have to do CEQA and you can get through the process in a reasonable period of time, that's a major incentive for developers to try to find a way to fit in those boxes.
Are a large number of these CEQA cases, do they fit into that criteria of these infill projects?
They're starting to. I think these pieces of legislation that are really starting to be used more these days are, you know, maybe only 4 or 5 years old, and they're just starting to get into the litigation mode now over approvals that have been given. So, you know, we will see where the courts go with this legislation. I mean, I suspect we're going to see more and more carve outs from CEQA as
I had I had a CEQA case. I don't do too much, but I had a CEQA case where at the time of filing, it was a very righteous CEQA case. And that about 30 days before trial, Sacramento amended CEQA to basically exempt the project I was challenging from CEQA. It was brutal. Those exemptions, they come fast.
Well, and you know, that's one of the challenges too of administrative mandamus practice, as any appellate litigation really is. You know, there's got to be prejudicial error, and if the law changes underneath you, you know, the courts will tend to apply the law as it exists when they make their decision, not what it was when you filed your lawsuit.
Right.
Yeah.
Hey, let me ask you this. I've never been involved in a CEQA case that dealt with tribal cultural resource preservation. Have you? And tell us a little bit about the interaction between those two, I guess, policy goals.
Yeah, this is a really interesting area that I've got a couple projects now involving tribal cultural resources matters. And this all stems out of a legislation, AB 52, that was passed, I don't know the date, maybe 5 or 10 years ago now, that in the CEQA process, lead agency, and that's the CEQA term for the public agency that kind of takes the lead on the CEQA document. And typically tends to be the agency that's in the lead on approving the project. So if it's a housing project, it's the city or the county the project is in. Has to go to the state and ask, hey, are there any state recognized tribes that are interested in projects in this area? And then they get a list back from the state, and then the lead agency contacts each of those tribes that are on the list and says, hey, are you interested in this project? Do you have concerns about this project? And if any of the tribes come back and say yes, then the lead agency essentially has to engage in what's tantamount to government negotiations with that tribe, to try to come to an agreement over how to identify and then mitigate whatever tribal cultural resources there might be. So it's really a new category of environmental impact in California as we come to kind of grapple with the state's history of kind of running roughshod over the native people here.
Well, what type of interest or resource would be? Can you give us some examples of some of the back and forth or the interests here?
You can have, you know, the kind of most dramatic example is if there is concern about whether there's, you know, a tribal burial site there or a tribal village site on the project site, and that can raise a whole host of issues of, how to deal with human remains and how to appropriately respect, the burials there, and whether you just cap remains in place or whether they should be transported somewhere else. So those can be the subject of some very sensitive negotiations.
Are there any, is there any interplay with the federal constitution? The Article 1, Section 8 gives plenary power to the Congress to regulate commerce with the tribes. I don't know if that, if it prevents the states from doing this sort of thing, where it's giving kind of first right of refusal to certain projects to tribes in the area.
I haven't seen that come up. And the federal government has its own, a separate list of the tribes that the federal government recognizes. And often the federal lists and the state lists don't match. So, I've never seen a case where there might be a conflict between what the state or local government might want to see done with the tribe and what the federal government might have deemed appropriate under the federal constitution. It's an interesting question, but I haven't seen it come up.
All right, let's talk about a recent case. This is actually the case that piqued my interest in talking about CEQA. It's Tiburon Open Space Community versus County of Marin. It's back in, it was issued in May of this year, 2012, out of the First District Court of Appeal. Just the thumbnail sketch of it is Tiburon. The Tiburon case involved a development project that was slated to be built atop a mountain that was overlooking San Francisco Bay. So it apparently had just majestic views. There were only some 46 or so suburban single-family homes that were slated to be built there, that the developer wanted to build there. For many years, the permitting attempts had gone on. Neighboring residents hated the idea, and so they opposed the project vigorously. In the course of decades of litigation, the county stipulated to a judgment, and ultimately the county took the position that judgment tied its hands and required it to issue the development permits. The neighbors contested this on appeal and argued that the county's position violated the fundamental principle that a sovereign cannot negotiate its own sovereignty, and that by taking the position that its hands were tied, the county basically abused its discretion, delegated its sovereign powers to the developer, and in such manner evaded the requirements of CEQA. The Court of Appeal rejected the argument, said no, the county didn't evade its CEQA obligations. And I wonder if Peter, can you elaborate on that? Did I simplify it too much? And what was really at stake here? Because coming up in a minute, I want to read there's some interesting quotes that are critical of CEQA, and I wondered if this was usual, this kind of a run-of-the-mill CEQA Court of Appeal opinion. What is noteworthy in this case, in your view, Peter?
Well, I'll say, first of all, this is one of the interesting CEQA cases. There are a lot, CEQA is a procedural statute, and there are a million rules in CEQA, both for lead agencies and for petitioners. And so when you've got a procedural statute like that with a lot of tripwires on both sides, you get a lot of court cases that by and large turn on kind of not very interesting procedural rules, at least in my opinion. But this is a more interesting one, I think. Because you've got this interesting interplay between these federal stipulated court judgments, which the county and the Court of Appeal thought constrained the county's discretion, and required the county to approve, I think it was 47 houses along a ridgeline. And the usual rule under CEQA that lead agencies ought to evaluate the environmental impacts up, down, and sideways of a project like this. But I think the Court of Appeal got this one right, for the kind of simple reason that CEQA, as I mentioned earlier, applies to discretionary decisions. And here, I don't think there was any suggestion that there was a collusive stipulated judgment here. In fact, the county opposed the underlying federal court case pretty vigorously when it was filed. But there nevertheless was a federal court judgment that required the county to approve this project. And so there really was not much to be done under CEQA. There was a EIR done, I guess, but in terms of what the county could or might have been able to do differently as a result of that environmental review, its hands were tied. It had to approve this project. So, I think the court got this one right.
Now, there was, as I mentioned, there were a couple of passages in the opinion that I thought were quite vivid, and I want to read a couple of them to the audience. The first one is provides just kind of a nice thumbnail sketch of what CEQA is and what its purpose is. The court quotes the late presiding Justice David Sills, who was my former boss when I was an extern at the Court of Appeal down here in Santa Ana, that CEQA, quote, provides protections to expose elected decision makers to the political consequences of any decision to certify an EIR. There is a sort of grand design in CEQA. Projects which significantly affect the environment can go forward, but only after the elected decision makers have their noses rubbed in those environmental effects and vote to go forward anyway, end quote. What do you think, Peter? Is that a fair, if pithy summation of what CEQA is?
I think it's a great summation. I'm not sure quite how much it applies in this case, but that's the idea. It's to kind of educate the decision makers and the public about every aspect of a project, and CEQA doesn't constrain the lead agency's actual decision making. It just puts all the cards on the table, and if they want to nevertheless proceed with the project, that's okay. CEQA doesn't stop a lead agency from doing that. It doesn't constrain their discretion. They've just got to jump through the 1,000 procedural hurdles to get to that approval. And then, decision makers, they live with the consequences of their decision. That's politics. And, they can, if they're proud of the decision they make, they can run on it. If they want to hide from it, well, then their opponents can highlight it for the public. But that's democracy in action. That's the theory. In this case, the county had to approve this project in the sense that it had to agree to a settlement. And so there was at least some public airing of what the project would be, and some opportunity, I imagine, for the public to weigh in on that point. But there wasn't the usual opportunity to rub the decision makers' noses in the environmental consequences of the decision. And what the petitioners probably should have done here was try to intervene in the federal case at the time the settlement was approved. And if they wanted to ask the federal court to try to build into that settlement, and oh, by the way, there should still be a CEQA process that the county should have to go through. And if they want an out from approving the project at that point, at the end of that process, then build that into the stipulated judgment. But once that judgment was entered, the county's hands really were tied. Otherwise, it'd be in contempt if it didn't approve this project.
All right, and then here is the conclusion of the court's opinion, and it's entitled "Some Concluding Observations." And so when I saw those words when I first scanned this case, I knew that we were going to have to talk about this. So here's what caught my attention in the first place. In the concluding observations, the court makes reference to Justice Chin's opinion in the California Supreme Court's opinion, Center for Biological Diversity versus Department of Fish and Wildlife. And the opinion states that Justice Chin had concluded with a warning worthy of Cassandra, quote, "We have cautioned that rules regulating the protection of the environment must not be subverted into an instrument for the oppression and delay of social, economic, or recreational development and advancement." And then the opinion goes on in its concluding observations that every member of the Supreme Court agreed that, quote, "CEQA is not intended as a population control measure," end quote. And then finally, delay can become its own reward for project opponents. This is a recipe for paralysis, but CEQA is not meant to cause paralysis. And then notes that this case vindicates some of the worst of Justice Chin's fears. And CEQA was meant to serve noble purposes, but it can be manipulated to be a formidable tool of obstruction, particularly against proposed projects that will increase housing density. Something is very wrong with this picture, is how the court concludes it. Peter, is this tone representative, you think, of how a lot of Court of Appeal justices view CEQA? This seems extraordinarily critical and seems to be kind of dipping a toe. It's, sometimes you see these opinions concluding, we urge the legislator to take this up. Is this kind of an implicit call that the legislature needs to do something about CEQA?
I think there's been a real change in tone in a number of CEQA cases by the Court of Appeal in recent years, and I've seen several cases where, in the 60s, 70s, 80s, 90s, you'd see the first half of the legal discussion being all about CEQA is meant to protect the environment, and now you see a lot more of this kind of language that CEQA is not meant to be the end all be all, and there are other values that are important. And with housing costs being what they are in California, and essentially the number one concern of Californians, it's not surprising that the courts are maybe taking a more critical eye towards what are we really doing here.
Yeah, there was also around the same time that the Tiburon opinion came down, there was this article written by Matt Taibbi about CEQA. And Matt Taibbi he's a former Rolling Stone essayist or writer. Now he's got his own blog at Substack. But he wrote an article called "The Lawyers Who Ate California," and it talks about various types of what he sees to be overregulation. But here's what he wrote about CEQA specifically. This is Matt Taibbi. Multiple other business figures cited CEQA, the California Environmental Quality Act, which accomplished good things at its inception in 1970, but has since seen exponential to cancerous growth, making home construction massively more expensive and pushing companies to relocate workforces to locales with more available housing. It was intended to modernize residential building, but CEQA, to some, has instead become a backdoor subsidy to owners of the state's stagnant pool of mid-century homes, mandating so many lengthy reviews and conditions that petitioners can NIMBY neighborhood projects to death and kill even environmentally friendly projects like bike paths and public transport. Even progressives have begun to feel empowered to openly hate on this statute. Democratic State Senator Scott Wiener called it, quote, "the law that swallowed California," end quote. So I wondered if you are seeing these kinds of sentiments. Again, CEQA, you would think is, all environmentalists would love CEQA because it's meant to provide environmentally friendly neighborhoods, but it can be used to obstruct just that objective.
It can cost hundreds of thousands of dollars for any kind of developer to fund an EIR, not even counting the mitigation measures that the EIR measure will require. I think part of the problem is that local agencies, there's sort of no end to the process. They have to do CEQA when they amend their general plans or amend their zoning, and then at the individual project level, developers have to do CEQA all over again. And it would make much more sense, I think, if local agencies, when they were doing their large planning documents, we went through CEQA once, we all decide here's where housing is going to go, here's where the transit's going to go, here's where the open space is going to be, and then let people essentially by right build in the places that are designated in the general plan to build, and not build where the overriding planning documents say we shouldn't be building, and not have to go through CEQA again and again and again. And I think that's actually a lot of the spirit of Senator Wiener's legislation. A lot of the legislation that we talked about earlier kind of comes from him. That essentially, if you qualify under the general plan and the zoning, then you get ministerial approval. This matter has already been studied and resolved, and we don't need to study it again just because now we're at the individual project level.
Do you see these CEQA issues and arguments as having a certain political bent to them? The Tiburon case involved a development involving single-family homes, but a lot of CEQA litigation or CEQA-based objections are neighborhood objections to high-density developments. And so I wonder if, sometimes you could see that as being, either side of the political spectrum. There's some left of center who would like to see more high density built, and they're more, more conservative type, or just not necessarily political conservative. I guess anyone who owns a home would like to see their property values maintain or increase. So is there a political angle to this, or does everyone agree that reform needs to be made here?
Well, I don't know what everybody thinks, but there are, there's this classic clash these days in California between the NIMBYs and the YIMBYs, the not in my backyards and the yes in my backyard groups. And when you get down to local politics, all politics is local, and sometimes people who might identify as progressives, like in Marin County, it's a very liberal voting anyway community. But here we're talking about 47 homes in the Tiburon case that engendered years and years and years of litigation and multiple lawsuits. And so I don't know whether it's, whether there's a difference between single family homes and multifamily housing. I've certainly dealt with litigation and entitlement work over both kinds of projects, and they have different issues. Single family homes often, they require more development footprint. And when you're building in more green space or open space, then you can have greater impacts to species, to wetlands, than you would if the development was concentrated, especially if it was concentrated in infill, existing neighborhoods. But I don't know that there's a traditional political bent that these groups fall into. It's very local.
Is there more energy in favor of building high density than lower density? And I guess by energy, I mean, I would guess that there's more. I'll tell you, from my perspective, I mean, I've got young children. I need a home with a yard. Living on top of a barber shop or a liquor store is not going to cut it for me. So the high density thing doesn't excite me when I hear about high density in my neighborhood or in my community. I want to see more single family homes, but we're pretty built out. But I wonder if there are developers who, we still have a lot of open space in California, but I don't know that I hear about too many single family developments going on. It's all the talk and energy seems to be in infill high density development.
Yeah, I think I mean, I've got a project right now in Vacaville where there's a mix. We've got single family homes, and then you've got multifamily apartment and condo buildings. And it really comes down to what the developer thinks the market will support. And there is a range of demand for housing depending on where people are in their lives, I think. And when I was in my 20s, living in an apartment, having an affordable apartment to live in New York, or even out here in the Bay Area, was something I needed. And there is a large group of people that need that kind of housing. But that doesn't work for everybody, obviously. And there should be supply of housing that meets everybody's needs.
Hey, Peter, I think our audience would be disappointed if I didn't slip in at least one anti-SLAPP question. You pointed me out to the fact that sometimes anti-SLAPP motions can be brought by public agencies against writ petitioners. And you pointed me to the Vargas versus City of Salinas case, which I had not read before. It was really interesting. That when a citizen complains about something the government is doing, the government can procedurally attack the complaint as an abridgment of the government's First Amendment rights. And I wanted to ask, does it make sense to you that the government is a person protected by the First Amendment within the meaning of the anti-SLAPP law?
Well, the California Supreme Court has said so, but I think it makes no sense. The First Amendment was designed as a limitation on the government's ability to restrict the speech of individuals, particularly individuals who complain about the government activity, and to protect petitioning activity by individuals against the government. And I've seen cases where I've brought petitions against public agencies, and they've responded with anti-SLAPP motions, which, as you both know, are very powerful tools, and oftentimes quite righteous, but can really make it hard for a petitioner to ever see their day in court, at least in a timely way. because they bring the proceedings to a halt. By and large, they're subject to immediate appeal, whether you win or lose the motion. And the fact that public agencies in California, the California Supreme Court has said, can bring anti-SLAPP motions against people trying to petition the government for the redress of a grievance makes absolutely no sense to me.
I tend to agree, unless it's the pure case where the lawsuit is filed as a result of a public official's speech and an individual public official sued. That might be the case where, you have a righteous anti-SLAPP motion. But I tend to agree, because there is the potential for a chilling effect on people's willingness to even risk an anti-SLAPP attorney's fee award by filing a simple writ petition.
Yeah, it seems to be one of those situations where the distinction matters, where they say, individuals have rights, governments have powers. Right? Government doesn't have a First Amendment right. Government just wields the big stick. Doesn't get to use the Constitution against the people. That's an interesting case. Peter, do you know, has there been any movement in that doctrine? This case that Jeff mentioned, Vargas versus City of Salinas, was back in 2009. So that's 13 years ago. You notice that is there any trend on that, or any decisions following that one way or the other?
There was a more recent decision. Oh boy, and I've got a this makes for bad radio, but there was a more recent decision by the California Supreme Court that I believe it was a labor dispute involving a university, where the university, the petition was really attacking the actual decision of the university and not any speech. And the California Supreme Court said, look, a public decision is not speech protected by the anti-SLAPP statute. And that struck me as correct. And if you give me just a moment, I'm sure I can find the case. But
yeah. Well, you can look for that. In the meantime, I wanted to ask you about, there was another case that you had told me about, and it has to do with administrative mandamus. And this can be, in the abstract, sound just as exciting as CEQA law, but this has a real punchline to it. So here, imagine, you have a citizen who's unhappy with an action by the city. Maybe there's a city ordinance that deprives someone of his property or liberty, or it's unconstitutionally vague. Now, your remedy is to file a petition for a writ of mandamus in the Superior Court. But Peter, you had pointed out to me that the citizen's remedy, even if he wins and gets the remedy he prays for, that mandamus remedy may be illusory. What do you mean by that?
Well, unlike in the courts of appeal, where you can get a remand with directions, where the court of appeal tells the trial court, all right, here's how you need to rule on remand. You never get that almost never get that in a writ of mandamus, administrative mandamus case. The courts are very careful, and I think this goes back to sort of separations of powers concerns. The courts are one branch of government, and administrative agencies come from another branch of government, and the courts are reluctant to tell the other branch of government what to do. So the almost universal remedy is simply just to vacate the decision and send it back, and that gives the agency just another crack at the whole thing. And if the legal challenge is, for example, you didn't make the appropriate findings, well, they just go back and they rewrite the decision and make the finding, and you're right back where you started. So it's very easy to win a battle but lose a war if you're not really careful in what the claims you're bringing are, and whether, as a practical matter, it becomes difficult for the agency to rule against you again on remand. But there's very little to stop them from trying. That was an observation that Justice Brennan made in one of the cases I sent you in a dissenting opinion. But yeah, sometimes you can lose the battle and still win the war. That's how easy it is to be a city attorney. And that's right. I've only succeeded once in getting a remand with directions. And that was in a coastal commission case. We were challenging a permit condition, a public access permit condition, which in our view went against the terms of a judgment, a prior judgment, that required this bridge of our clients to be kept private and not open to the public. And there is a severability clause in the Coastal Act, and we said, look, this clause allows you to sever invalid provisions and leave the rest in effect. And the Court of Appeal, unfortunately, in an unpublished decision, agreed with me and remanded with directions. But that's the only time I've ever seen it happen. It's quite rare. So you got to, if you're bringing a writ case and you're advising a client, I'd say, you don't want to bring a claim that's easy for the agency to fix, because you may just be wasting your client's time and money. You want to prevail on a claim that might have a real chance of constraining their discretion next time around.
Well, Peter, when you emailed me with this case, you'd quoted this line: "See how easy it is to be a city attorney. Sometimes you can lose the battle and still win the war." And when you in your email, when you quoted that to me, you had a case after it. Justice Brennan dissenting. I thought that can't really be in a Supreme Court decision, even a dissenting one. But I looked it up, and lo and behold, here's what it says. Justice Brennan, in a footnote, Justice Brennan's quoting a city attorney giving this advice at a conference of the National Institute of Municipal Law Officers in California. The quote is, here's the heading of this advice by a city attorney: "If all else fails, merely amend the regulation and start over again. If legal preventative maintenance does not work and you still receive a claim attacking the land use regulation, or if you try the case and lose, don't worry about it. All is not lost. One of the extra goodies contained in the recent California Supreme Court case of Selby versus City of San Buenaventura appears to allow the city to change the regulation in question even after trial and judgment. Make it more reasonable, more restrictive, or whatever, and everyone starts all over again. See how easy it is to be a city attorney? Sometimes you can lose the battle and still win the war. Good luck." End quote. So that's the footnote from Justice Brennan in San Diego Gas and Electric Company versus City of San Diego. How glib and cynical it is. Now, this opinion was back in 1981. Peter, do you have any idea whether this attitude persists among city attorneys?
What I would say is city attorneys are looking for ways to protect their clients, just as everyone else is. I'm trying to be diplomatic here, but mandamus it's an equitable remedy, and even if a public agency loses in the trial court and takes a matter up on appeal, if they then amend the regulation even while the appeal is pending, the Court of Appeal is likely to say that's going to moot the appeal, and that's a special power that a public agency has, because it has lawmaking and adjudicatory powers that private parties often don't. And if the trial court has identified a problem in your decision, and you have the power to fix it and maybe save some litigation exposure and uncertainty, then it doesn't at all surprise me that good city attorneys might advise their clients to be proactive.
Yeah. Well, you mentioned this goes back to a separation of powers concern on the part of judges. They don't want to. They have to review the petition in front of them, but they don't want to cross the line into telling city councils, sovereigns, how to do their job. Do you think they strike the right balance? You mentioned that sometimes they do issue remand with directions. Do you think they strike the right balance in holding back in the majority of cases, in your experience?
Well, it's interesting to contrast this attitude with what we saw in the Marin, the Tiburon case, where you actually did have a stipulated judgment, but nevertheless a judge signed it. And maybe it was because the county in that case at the time thought that was the right resolution, and so the court was less reluctant to be seen to be telling another branch of government what to do. But yeah, I think it tends to be good practice in cases where a public agency is involved to try to get a stipulated judgment where you get a court order at the end of the day, rather than just a settlement and a dismissal. Because city councils change, and but a federal court order is forever sometimes.
Yeah, there you go. Yeah, that's one of the other doctrines, is that city councils cannot bind future city councils.
Yeah, but that that is certainly limited when it comes to a city council's decision that then gets the force of a judgment behind it. Res
Correct.
judicata can be even more powerful sometimes.
All right. Well, Jeff, should we move on to the lightning round?
Sure. It's been a long time, but Peter looks like he's well rested and ready to to face the music. This is the time for our patented copyrighted segment that answers the most pressing questions that vex appellate nerds around the world. Short responses, one sentence when you can. Let us know what is your font preference: Century Schoolbook, Garamond, or something else?
In letters, I use Palatino. In appellate briefs, I use Century Schoolbook.
Very good. Very good. I think I know the answer, but 2 spaces or 1?
2 spaces. I'm sorry, guys.
Yeah, very good. No, that's
filing a minority report.
Guy. Superior Court or Superior Court. Do you capitalize the S and C in Superior Court?
I do. Especially if I'm talking to that Superior Court. Yes.
Interesting. All right.
Let me go back real quick, Peter, to the 2 spaces. Is that I can't leave it alone? Is that answer informed by your international experience at The Hague and in London and elsewhere?
No, but maybe it's informed by the fact that I've had to wear glasses since I was 5 or 6 and have a harder time seeing sentence breaks where there's only 1 space rather than 2. So it's purely a help the reader, meaning myself and my bad eyes, concession.
That I award that a valid
exemption.
justification.
All right. Do you put a table of contents entry in your table of contents?
I don't, though. I had this discussion last week with one of my other partners who does put it in there, and maybe I'll change, but I think it's a little silly. I guess it's required by the rules, I'm told, but and I like to comply with the rules. I'd hate to have a brief kicked. Sorry, I'm violating your 1 sentence rule, but
that's okay.
So far,
Tim
no.
led us astray, and now we're just it's the bogged down swamp round instead of the lightning round.
But so far, I've gotten away with it with leaving it out. So,
all right. And when you have headings in your briefs, all caps, initial caps, or sentence case?
I now do sentence case, at least for the sort of 2nd level headings. And I think you guys have turned me around on that, or maybe some of your other guests have. But I think it's
easier on the eyes.
Yeah, it's much easier on the eyes, and I think it's another way to persuade your reader or explain to your reader what your arguments are if you use a full sentence in a font that people can actually read.
Yeah.
The title case has come to jump out the page at me and just strike me as extraordinarily offensive now.
Calm down, Tim. And final question, after major headings in your briefs, do you start the next section on a new page or you continue immediately below?
It depends. Okay. It depends. If I'm sort of maybe more than halfway down the page, then I'll start it on a new page. If there's only a few lines to wrap up the previous section, then I'll probably keep it on the same page. But I don't have a strong opinion about that one.
Is that a new one, Jeff? What's your practice?
They don't charge you for white space, Tim. I'm a big fan of using as much white space as you can. To really...
In trial court briefs where you're page limited, you wouldn't go on to the next page.
It's costly in trial court
briefs. There's always room to trim words. Always room. And white space really is undervalued, I think, in terms of making it readability. All right. Well,
I don't know how often you guys put pictures in your briefs, but I use them more and more these days. I think they are worth 1,000 words, and they do take up some space, but boy, can they be powerful.
Absolutely. Yeah. I love them. Look, I think I mentioned this podcast before, but I'll say it again. When the Supreme Court ruled about prayer on the 50-yard line and what was happening at the 50-yard line in football games, Sotomayor had not 2, but 3, I think, photos of what was happening. And those photographs were really powerful presentation of what was going on. All right, I violated my own rules about the lightning round. You've survived the dreaded lightning round, and one day we'll send you a cup or a mug or a T-shirt when we have such mugs or T-shirts.
Look forward to it.
All right, Jeff. I think we just had a couple of tidbits we wanted to share with the audience.
Yeah.
There's one I found about frivolous motions, and when I advise attorneys, these are frivolous motions for reconsideration specifically. Now, when I advise attorneys and clients about whether to file a motion for reconsideration, I've come to feel like I'm in a no-win situation, because on the one hand, even if you have no new facts and no new law, and even if you've blown your window to file the motion for reconsideration, the California Supreme Court in Brown, Winfield, and Canzaroni has held that doesn't prevent the trial judge from reconsidering anyway. Quote, "It should not matter whether the judge has an unprovoked flash of understanding in the middle of the night or acts in response to a party's suggestion." So on the one hand, I'll say, sure, file the motion for reconsideration. What can it hurt? But here's how it can hurt. On the other hand, if a motion for reconsideration is meritless, frivolous, or filed in bad faith, the trial court may order sanctions against the movement under Section 128.7. That is what happened in Banks versus, how do we pronounce that? Mastorakis. That's out of the 2nd District, 2nd Division. It's an unpublished case, but there a lower court imposed a $960 sanction against plaintiff for bringing a frivolous motion for reconsideration after an adverse summary grant, a result affirmed on appeal because the reconsideration motion did not mention any new facts and cited improper statutes and ordinances. Now, so this goes really undermines my original advice that maybe just file the motion for reconsideration, because maybe the judge will just have a flash of new understanding that it got it wrong the first time. I would guess, Jeff, that most motions for reconsideration probably are technically invalid for one reason or another. Yeah. Mostly they're just filed in hopes of getting the judge to have that flash of new understanding that the ruling was wrong the first time. But the Banks versus Mastorakis case is a reminder of the risks of sanctions for bringing an invalid motion for reconsideration.
Yeah, motions for reconsideration are usually filed when a lawyer doesn't have good client control and can't take the loss.
I just had my first one granted, actually, not too long ago.
I stand corrected. All right,
but it was a posture where we'd had a TRO denied in state court, and then one in a related pending federal action in the Ninth Circuit. We won a stay of the judgment pending appeal, and we won it within the 10 days, so we weren't out of time, and we brought that to the trial court's attention, and the trial court said, yeah, that's a new fact, and so I'm reconsidering this denial, and it was the right result, but I was still pretty surprised that it actually is possible to win one of those motions.
But if you get one of those safe harbor letters served on you, you got to take it very seriously now.
Yeah.
Interesting. All right, and I want to bring to attention one issue that's happening down here in LA. Tim, when I first started practicing law, you show up to court. There's always a court reporter there. And then a few years back, because of budget cuts, they started taking away all our civil reporters. So in civil matters, you didn't have court reporters, but you still had them in family law courts, probate courts, and writs and receivers. Well, no more. In LA County, they've just announced no more court reporters will be automatically provided for family law, probate, and writs and receivers. So lawyers practicing in those courtrooms in LA Superior Court need to bring their own reporter.
Yeah, that's going to be tough. There's been a shrinkage in the availability of court reporters. I'm not sure what that owes to, but maybe we can, I'll do some sleuthing and see if we could bring our audience some more information about that.
We'll include a link to the Southern California Appellate News blog. Ben Schatz actually posted a story about this and indicated it's really a shortage of reporters. It's not even a pay issue. It's just they don't have the bodies. It'll be interesting when following the absence of these reporters, when there's appeals and appellate lawyers like us start doing motions for settled statements, and the courts get bogged down with having to revisit all of these disputed matters. I suspect a solution to the reporter shortage will manifest itself.
I love a good court reporter. And at every deposition I'm involved with, I always at the end of it ask the court reporter, hey, what do you think of this witness? Because they've seen more witnesses than I have, and if you can pigeonhole the court reporter at the end of a deposition and get their take. I find that can be sometimes pretty valuable. Practice tip.
Yeah.
That's funny.
All right, Jeff, and you had one more about slap motions. I'm gonna save this retroactivity and the 3 strikes law to a future episode.
Okay, yeah. Then the final point we'll bring, and then we'll conclude is it's long been the case in the Ninth Circuit that this Ninth Circuit's allowed anti-slap motions to be heard in federal district courts. And on August 30th, 2022, a 3-judge panel rejected yet another challenge to this rule. The case is Core Civic versus Candide Group. And it'll be interesting to see if this decision is, there's a petition to hear this en banc, because I've read dissenting opinions and seen writings where a lot of Ninth Circuit judges are not happy to have anti-slap motions heard in the Ninth Circuit. So I would be shocked if there's not a petition to rehear this en banc. So that was it for me for tidbits, Tim.
All right. Well, sounds good. So that wraps up this episode. And again, we want to thank Casetext for sponsoring the podcast. Each week when we include links to the cases we discuss, we use Casetext for our cases. And listeners of the podcast can find a 25% discount available to them if they sign up at casetext.com/CALP. And if you have suggestions for future episodes, please email us at info@calpodcast.com. In our upcoming episodes, look for more tips on how to lay the groundwork for an appeal when preparing for trial.
Yeah, email us if you're a maritime lawyer and you want to come on the show and explain what maritime law is. See you next time.
Thanks again, Peter, for joining us.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.